5 seconds to go. Start. Heard learned counsel for the parties. This appeal by special leave is directed against the judgment and order dated 11th February 2020 passed by a division bench of the High Court of Jharkhand at Ranchi. Briefly, the High Court hereinafter in LPA number 505 of 2016. Appellants are the State Bank of India and its officers. Respondent, an officer of the State Bank of India (SBI), was subjected to a disciplinary proceeding following which the penalty of dismissal from service was imposed on him. Departmental appeal filed by the respondent against the dismissal order was rejected by the appellate authority, so also the petition for review. Respondent filed a writ petition before the High Court challenging the order of penalty as upheld by the appellate authority and the reviewing authority. Learned single judge allowed the writ petition and set aside the order of penalty on the ground that the disciplinary proceeding was initiated after superannuation of the respondent, including the extended period of service. Therefore, such disciplinary proceeding was held to be void ab initio and the consequential order of penalty set aside with a further direction to the appellants to pay the retiral and other dues of the respondent. Appeal filed by the appellants was also dismissed by a division bench of the High Court. Against such dismissal of the latter's patent appeal, special leave petition civil number 11413 of 2020 was filed by the appellants. This court, by order dated 16th October 2020, had issued notice. As an interim measure, it was directed that the contempt proceedings stated to have been initiated by the respondent against the appellants before the High Court be deferred. The matter was finally heard on 23rd January 2024 when leave was granted. Before proceeding further, it would be appropriate to briefly encapsulate the relevant facts so as to have a proper perspective of the list. Respondent was appointed as clerk typist in the SBI on 8th June 1973. He was promoted from time to time. On completion of 30 years of service, respondent was due to superannuate on 26 December 2003 as per the State Bank of India officers' determination of terms and conditions of service order 1979. However, by order dated 5th August 2003 issued by the competent authority, respondent was given extension of service from 27th December 2003 to 1st October 2010. On 18th August 2009, a notice was issued to the respondent by the appellant SBI calling for his explanation as to why disciplinary action should not be initiated against him for violating instructions of SBI. The allegations highlighted in the notice mostly pertained to sanctioning of loans by the respondent in favor of his relatives in deviation of banking norms and missing of documents related to sanctioning of the loans. On 21st August 2009, respondent was placed under suspension. Respondent submitted reply dated 27th October 2009 to the notice dated 18th August 2009. However, it appears that the disciplinary authority did not accept such reply of the respondent. Thereafter, on 18th March 2011, appellants decided to initiate disciplinary proceeding against the respondent in terms of Rule 68(1) of the State Bank of India Officers Service Rules 1992, for short the Service Rules hereinafter. Deputy General Manager Operations and Credit Northwest 2nd Jharkhand, acting as the disciplinary authority, issued show cause notice dated 18th March 2011 enclosing therewith articles of charges supported by a statement of allegations and a list of documents on the basis of which the charges were framed. The charges were the same as the allegations in the previous notice issued on 18th August 2009. Respondent was called upon to submit his written statement of defense within the prescribed period. It may be mentioned that the disciplinary authority had appointed an inquiry authority to conduct the inquiry against the respondent. On 29/11/2011, respondent submitted his defense brief denying all the allegations totaling 20. Inquiry proceedings started on 24th May 2011 and concluded on 6th September 2011. Thereafter, on 8th December 2011, the inquiry officer submitted the inquiry report to the disciplinary authority. Out of the 20 allegations, the inquiry officer held that 16 were proved, 3 were partly proved, and 1 not proved. The disciplinary authority vide the forwarding letter dated 17 December 2011 forwarded a copy of the inquiry report to the respondent, calling upon him to respond thereto within 15 days from the date of receipt of the report. Respondent submitted his reply to the disciplinary authority on 15th January 2012, pointing out various flaws in the inquiry report and requesting the said authority to drop the proceeding. The disciplinary authority, however, passed order dated 7th March 2012 imposing the penalty of dismissal from service on the respondent. Respondent preferred an appeal against the order of penalty. However, by order dated 26 October 2012, the appeal of the respondent was dismissed. It was thereafter that respondent preferred a review petition, which also came to be dismissed by the reviewing authority, vide the order dated 16th January 2014. Aggrieved thereby, respondent preferred a writ petition before the High Court assailing the order of penalty dated 7th March 2012 as affirmed by the appellate authority, vide the order dated 26th October 2012 and by the reviewing authority, vide the order dated 16th January 2014. The writ petition was registered as WS number 3446 of 2014. Vide the judgment and order dated 6 September 2016, a single bench of the High Court held that service of the respondent was extended till 1st October 2010 after his superannuation in the year 2003. There was no further extension of service after 1st October 2010. Departmental disciplinary proceeding was initiated on 18th March 2011 when the charge sheet was issued by the disciplinary authority to the respondent, which was admittedly after 1st October 2010. Therefore, the appellant bank, that is SBI, had no jurisdiction to initiate departmental disciplinary proceeding beyond 1st October 2010. That being the position, the order of penalty dated 7th March 2012, the order of the appellate authority dated 26th October 2012, and the order of the reviewing authority dated 16th January 2014 were set aside and quashed. Appellants were directed to extend consequential service benefits to the respondent. The aforesaid judgment and order dated 6 September 2016 passed by the single bench was assailed by the appellants before the division bench of the High Court in LPA number 505 of 2016. While the judgment and order dated 11th February 2020, the division bench concurred with the view of the single bench and held that departmental disciplinary proceeding could not have been initiated and continued after superannuation of the respondent. Consequently, the division bench dismissed the latter's patent appeal of the appellants as being devoid of any merit. Stop.